documentation, and record keeping. All the information in this section has come from the following sources: Health and Safety Executive UK Government. https://www.hse.gov.uk/blood-borne-viruses/safe-working-practices.htm. https://www.hse.gov.uk/priced/L5.pdf. In this section, we will look at some of the most important documents and records both you and your employer should know about and be adhering to so that a safe work environment is achieved. Some of these are best practices and others will be a legal requirement, so be sure to know which ones apply to you and your studio. Health records for those at risk of BBVs. It is a statutory requirement to keep health records in relation to work involving risk of exposure to blood-borne viruses, under COSHH, Regulation 11(3). Health records are not medically confidential documents. They provide feedback to management on the results of health surveillance for the purpose of safely deploying individual employees, as well as collectively monitoring the effectiveness of immunization in staff at risk. Health records should be held by and available to managers even when separate occupational medical records are also kept. Unless the employer can demonstrate that reasonable access to these records is available to deploying managers at all times that the relevant staff are working, e.g. through some other means, such as health records retained by an occupational health department. Health records for those working with biological agents such as pissers, tattooists and others in the body art industries require more detail. For example, a historical record of work with or exposure to BBVs. This is particularly relevant for infectious agents that have the potential to cause persistent or latent infections, or which may have serious long-term consequences, i.e. hazard group 3 biological agents, and BBVs with potential for causing subclinical, chronic infections, are regarded as Category 1 carcinogens, such as hepatitis B and hepatitis C. Care of substances hazardous to health, or COSHH. This section is from Guidance 3. The following table summarizes the scope of the employer's duties under COSHH towards employees and other people likely to be affected by the work, e.g. contractors, visitors to a site, and where biological agents are concerned, clients in a studio. However, there may be more wide-ranging requirements, e.g. under the Management of Health and Safety at Work, MHSW. Regulations. SFARP stands for So Far as Reasonably Practicable, and an explanation of this is provided at https://www.hse.gov.uk/theory/lrpglance.htm. This shows a table of duty of employer relating to different situations, and the duty of those in the workplace. One of the most notable regulation sections in the document is Section 3, with the guidance for that section being as follows. People working under the control and direction of others. 43. Only the courts can give an authoritative interpretation of the law. However, when deciding whether duties under COSHH apply, the following points should be considered. 1. People working under the control and direction of others may be treated as self-employed for tax and national insurance purposes, but they may be treated as their employees for health and safety purposes. 2. It may, therefore, be necessary to take appropriate action to protect them. 3. If doubt exists about who is responsible for the health and safety of a worker, this could be clarified and included in the terms of a contract. 44. A legal duty under Section 3 of the HSW Act cannot be passed on by means of a contract, and there will still be duties towards others. The most detailed regulation regarding documentation in the workplace in regards to COSHH is Regulation 6. This is the main part of the document that outlines the risk assessments that need to be carried out to conform to the COSHH legislation as it applies to people in the workplace. Regulation 6 Assessment of the risk to health created by work involving substances hazardous to health is too large to go through here in the detail that is needed, so we have linked the document below for you to look over and use in your own studios. Incident reporting. Under the Reporting of Injuries, Diseases and Dangerous Occurrences Regulations 2013, RIDA, infections and dangerous occurrences with biological agents at work must be reported. Dangerous occurrences are certain unintended, specified events, which may not result in a reportable injury, but which do have the potential to cause significant harm. For an incident to be reportable as a dangerous occurrence, the incident must have resulted, or could have resulted, in the release or escape of a biological agent likely to cause severe human illness or infection, or a sharps injury involving known blood or body fluid infected with a blood-borne virus, BBP. In addition, local records should be kept of all such incidents, and the underlying causes should be investigated and noted. All other injuries should be referred to the standard operating practices you have in place, such as injury books and incident logs that you may keep. This being said, there are some mandatory incidents where you have to make reports under RIDA. Some occupational exposures to blood-borne viruses, HBV, HCV and HIV, are reportable to the HSE under RIDA as follows. Regulation 7 Dangerous occurrence, any accident or incident which results, or could have resulted in the release or escape of a biological agent likely to cause severe human infection or illness. Regulation 4.2 An over 7-day injury, if exposure to the blood-borne virus resulted in the worker being absent from work for 7 or more consecutive days, or Regulation 9.b Disease if exposure to the blood-borne virus resulted in the worker acquiring an infection as the result of an occupational exposure to a biological agent. Occupational exposures to blood-borne viruses that result in the worker being incapacitated for more than 3 consecutive days must be recorded, but are not required to be reported.